Any mention?
May I please, Your Lordship? I beg to mention item number 9, Lordship.
Yes.
Due to personal difficulties, Lordship, up to 2 weeks, Lordship.
No objection, Your Lordship.
And on prayer made on behalf of the petitioner, list after 2 weeks. Yes.
Highly
Much
obliged,
obliged, Lordship.
Please, Lordship, I beg to mention item number 3. I pray let this. Lordship, I pray let this matter maybe come up after 3 weeks, Your Lordship.
Yes, this is that
Promotion.
Promotion matters.
Now, it was informed on the last occasion, then promotion was accorded to the members of your
Yes,
association.
yes, my lord. My lord, the only surprising part is that this, if lordship will look into the case, my lord, the cause cyclist association, they have come as an association, but they are members of the association who has got a promotion, my lord.
That is what.
So, my lord,
Yes.
who
See,
are
it
the
was
individuals?
submitted on the last occasion by the senior
My lord,
counsel.
that has been what we have
The
been
promotion
saying
has
from
been
day one.
accorded. The
But-
so far as the grievance of promotion is concerned, that has
Yes, my
been
lord.
But only the seniority.
Seniority and all
yes.
those things. Whether seniority was a claim in the petition, was it there? Anyway, we'll just see. We'll see it. Just, you have any objection to the prayer?
No, my lord.
Just say on prayer made on behalf of the petitioner, not objected. Well, any counsel can respond and list after 3 weeks. Yes.
Highly obliged.
May I please, Your Lordship?
Yes.
Like to mention item number 4, Your Lordship. I pray for 2 weeks' time, Your Lordship.
Yes.
Yes, Your Lordship.
No objection.
No objection, Your Lordship.
This is what? This is a service matter.
Yes, Your Lordship, but it is it is pending for 2 years.
This is 2021 matter, so
Yeah.
more than 2 years.
But adjournment it's okay, Your Lordship. After 3 weeks, it can be done. If the petitioner is having any problem
When
after
you
2
want
weeks, 3 weeks,
After 3 weeks, Your Lordship.
After?
So that 3 weeks, Your Lordship.
After 3 weeks.
so that you can finish it up as well.
The same order. Prayer of the petition not objected to by so and so. List after 3 weeks. Yes.
Highly obliged, Lordship.
Much obliged, Your Lordship.
Sure, back to mention item number 10, my lord. Matter may kindly be taken up next week, my lord, subject to your lordship's convenience.
Next week there is no such. There will has to be after 2 weeks, Mr.
All right, my lord.
Probably there is. Yes, this is a new matter. Sure. This 13 on prayer made on behalf of the petitioner. List after 2 weeks. Yes.
Much obliged.
May I please, Your lordship?
Yes.
My lord, 6 and 7.
Yes.
This is the enforcement inspector, my lord, of the transport department. The main matter is pending before the Supreme Court, my lord. This is the same case. The appeal is pending before the Supreme Court.
These are connected matter pending.
My lord, the same petitioner, my lord, has filed 2 cases.
That has been recorded earlier.
Yes,
Petition
madam.
also. That's the order. Okay, just check the last order. Then when do you want it?
My lord, let this matter come after 4 weeks, my lord.
Just see the last order, and then you say the council, depending for the parties, submit that the matter is pending with Supreme Court. Okay. List after 4 weeks. Just, yes.
Much obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 2. I beg to mention item number 2, Your Lordship.
Item number 2.
Yeah. We are praying for 2 weeks' time, Your Lordship.
Why? Mr. Diengdo is on leave.
No, Your Lordship is having some personal difficulty, Your Lordship.
Who is the other side here? Just you inform the other side.
Sure, Your Lordship.
This also on prayer of the petitioner. List after 2 weeks.
Much
Yes.
obliged, Your Lordship.
Supplementary cost list. Item number 1.
Yes.
This is a pension matter, my lord, filed by the petitioner,
Who is the petitioner?
Mr. N.I. Chaudhary,
It's a local council.
local council, yes.
None of peace with the petitioners. Mr. Ahmed, Rana council is present on your appeal for.
For the sole respondent, madam, MTC.
Who doesn't on behalf of respondent? Just list after. When shall we list it?
I can seek instructions, my lord, 3 weeks.
No, we am not issuing notice. You do not have to seek instruction.
All right, madam.
Somebody will have to move the petition.
All right, madam.
List after 1 week.
Much.
Daily cause list, item number 1.
Bless you, Lordship.
Yes.
Wait, please, Your Lordship. Lordship, this is that subsidy matter, Lordship. The petitioner company could not fulfill their export obligation.
Who is appearing for the petitioner?
Sir K. Paul, Lordship.
None appears for the petitioner. MS Sobran, Learned Counsel is present on behalf of the respondent. You are appearing for all the respondents?
Lordship.
All the
Yes, sir.
respondents. There are 5 respondents. Just say, warrants of justice. List this matter after 2 weeks.
Lordship, last.
Item number 8.
Do not say hands of justice, just say list after 2 weeks. Yes. Yes, Mr. Sen.
Increase your Lordship.
Yes.
This matter relates to non-disposal of my mutation application by the cantonment authorities. But before your Lordships, there are 4 petitioners. Their deceased predecessor had during his lifetime acquired a property, a leasehold right in a property situated in the cantonment area by way of a registered deed of gift. Whatever formalities there may be for the approval and for the transfer of the deed of gift by the cantonment authorities, what happens, my lord, is if a party chooses to transfer a leasehold right in the cantonment areas, they have to take prior sanction or approval from the cantonment authorities. So all of this was done, and the donor of this particular gift, who's also arrayed here as the respondent number 3, obtained all these approvals from the cantonment authorities, and all after processing it, a gift deed was executed and registered before the sub-registrar. Thereafter, certain mistakes were noticed, and it was suggested a rectification be issued. So a rectification deed was also executed between the parties. So the matter rested at that. Thereafter, the predecessor filed an application for mutation of his rights in the general land records of the cantonment. Cantonment asked us to submit an amount about 10,000 rupees for publication of a notice, generally to invite any kind of objections from any parties that may be interested. That was also done, and thereafter some of the private respondents filed an objection. The summary of their objection is this, that the donor allegedly is a person of unsound mind, and number two, that this transfer,
Which way objectors are related to the donor? What is
some of them are family members, some of them are leasehold occupants, co-lessees of that particular holding. So they say that he's a person of unsound mind, and number two, that the transfer is in violation of the Muslim personal law. That is what their summary of their challenge is. Now, on the basis of this challenge, the matter remains pending, and ultimately, my predecessor expires in 2013.
Now, according to the objector, this property, who is the rightful claimant to the property? Who has the rightful?
The donor. That is the respond number 3. So they claim under Muslim personal law,
Okay,
he
so
can
they
only
say
give
the donor is mentally unsound.
unsound. That is their claim.
And then, okay, now that claim is made by
The objectors.
that is okay by supporting any medical certificate. Whether
Nothing whatsoever. So they just make a frivolous claim that he's of unsound mind. Number 2, the question is unsound at what point? Was he unsound at the time when the gift was actually made?
You are related to the donor. What is your relation?
I'm not related. I was a tenant in that property. We developed a very close relationship.
You are an outsider.
Lots. So their claim is under Muslim personal law, a person can only gift a maximum of 1/4 of his share in the property. He cannot claim beyond that. So that's a different issue.
Even if it is his self-acquired property also.
As far as the donor is concerned, yes, my lord. I'm not sure how. He must have purchased it from somebody. So it's a self-acquired
There is
property.
a custom like that. That's a. Is
Under
this a-
Muslim personal law, yes, my lord.
Is it? So
Apparently. So there is a prohibition with regard to gifting more than 1/4 of a share of a person's property. So the rest is reserved for the family members, for the heirs. So this is their claim. So all of this was filed before 2013, and my predecessor expires in 2013. The cantonment does not act on this matter. They neither allow my mutation nor reject my mutation application. Thereafter, I step into the shoes of my father, and I renew this mutation application. I write several letters to the cantonment authorities. Cantonment does not act on this matter. So therefore, I'm compelled to approach this honorable court by way of a writ petition. My prayer is very limited. Please accept my application, address it. Either you reject it or you allow it.
Who is appearing for the cantonment?
Cantonment Mr. Mahanta is not here.
So what is to be done? If the prayer is very limited.
No, it goes beyond this, my lord. I'll just conclude just on the facts. There's a little more. I have informed my learned senior. He said he'll be here shortly. So after I file my writ petition, there are some other private respondents who come forward with an application for impleadment. That impleadment application is allowed. They're also arrayed as parties subsequently. Now thereafter, some sense prevails. The private respondents file a civil suit before the court of the assistant district judge. Their claim is very simple. They make a declaration, they seek a declaration that the instrument of the gift is invalid, it's void. And they ask for consequential relief such as mandatory injunction prohibiting any kind of mutation. Now that matter is pending. After I receive notice, I enter appearance, I file an application under Order 7 Rule 11 because they had notice of this gift very far back. 2021 they filed the suit for the first
What
time.
happens in the civil suit will not take into
My lord,
consideration.
absolutely. So that is where it
Order 7
rests.
Rule 11 is pending.
It's pending. So the civil suit is pending with my 711 application which is to be heard. And as far as this is concerned, the private respondents have also filed their affidavit. Again, the similar objection that they've taken is the person is of unsound mind. When was he of unsound mind? We don't know.
Anyway, now the suit
And
will take care of it.
Lordship. And they enclose some documents, medical documents, where he is declared as a person of unsound mind only in 2021. Only in 2021, right before this case is filed. Now, thereafter, the cantonment also files their affidavit.
When this gift deed was executed?
My lord, gift deed was executed. Just a minute. On 23rd August 2001.
And after 20 years, he was declared unsound.
So the only document that they produced on record in their affidavit is one from 2021. A medical certificate that he's got 50% disability.
Yes.
Now, be that as it may, what is interesting is the cantonment's affidavit, my lord. Cantonment now files an affidavit and they adopt the entire affidavit of this private respondents. They say, matter was pending before us, disputed questions of fact have been raised, and a civil suit is pending. Because a civil suit is pending, our hands are tied, we cannot proceed in this matter. Now, interestingly, I have filed a rejoinder to this.
Have they passed any order saying that they
No,
will
not yet,
consider
not
the application only after the disposal of the civil?
No. And Manoj will just bear in mind that this civil suit was filed after I approached this Honorable Court. So Cantonment now adopts that as a ground for not proceeding with my mutation application. Now, against that, I filed a rejoinder. Lordships, can you take my rejoinder for a moment? This is filed on 8th August 22. I'm just trying to summarize the area of dispute. my
Yes,
lord.
yes, we have also not taken any note. You see, like.
Lordship.
Your rejoinder filed.
Rejoinder filed by the petitioners.
Which date you have filed?
Well, it's in August 2022.
Yes.
Let's please look at the annexure at page 8.
Page 8. Annexure
So
1.
I have just found a case, and this could be one of many, where the cantonment has taken a very different stand. In my case, they say, since there is a civil suit pending, we cannot proceed in the matter. There is another case relating to a different holding, where similarly there were objections filed to a mutation application and there were pending civil suits. There the cantonment allowed it. Now here, my lords, is an application, this is an order dated, communication dated 11th June 2020, issued by the CEO of the cantonment. It is addressed to Shri So-and-so, holding number 3JB, subject regarding repair and maintenance of house. Your application dated so-and-so. Your attention is hereby invited to this office letter number so-and-so dated 14/9/18, wherein you had been informed that the Cantonment Board by CBR, CBR stands for Cantonment Board Resolution. The board sits together and take a resolution. Number 5 dated 14/9/2018 has considered the matter of mutation of leasehold right of holding number 3JB and resolved that the mutation of leasehold right of holding number 3JB, Jhalupala Bazar, Shillong, Cantonment be carried out in the name of Mohammed Sabir. This is his brother. As the same does not confer any right, title or interest with the condition that the mutation shall be subject to the outcome of pending court cases.
They can take a call on
This is correctly done, well considered. They should have taken the same stand in my case. My case has been very arbitrarily decided. So now, settled position of law from the 19th is that mutation is a summary proceeding. It is purely based on prima facie documents and settled position. As far as the question of title is concerned, they cannot, revenue authorities cannot go into that. The entries in general land records is done only for fiscal purposes, for revenue purposes, nothing more. As far as the question of title is concerned, that has to be decided by the civil court. They cannot appreciate any evidence. They cannot decide the question of title. So these are two independent proceedings which are mutually exclusive. So in my case, they should have taken the same stand, that it shall be subject to the outcome of the civil suit. But they say we'll keep it pending because the civil suit pending.
So adoption of two different years.
Two different. And my lords, mutation proceedings, I have judgments which say it cannot be adjourned sine die. They have to take a decision, either reject it or allow it. And
It's okay, let them take a call. We
My
cannot
lord.
even direct also to them to take the same view, which whatever has been done. You see, like the order which you have referred just now,
My lord.
in your rejoinder affidavit, we cannot even pass a direction telling them to pass the same kind of order. That is
What I would
but
pray,
they
my lord,
should
should
take a
really
call.
take note of the fact that they have taken a stand insofar as another case is concerned. So there can't be any arbitrariness in their actions. That is all.
Yes, Mr. Upadhyay, you are for?
I am for the private respondent's lodge. For
You
the
are very
respondent number
limited, say, at this stage.
327. Lordship, as far as the application for this to be decided by the authorities, that can be.
That is what we see.
That
We
is
cannot go beyond that.
not-
We cannot
not
direct
beyond
them
that.
in which
As far
manner
as
it
the-
should be passed.
Which my learned friend has read, the annexure 1 of the rejoinder affidavit. Lordship, if the mutation is for the purpose of paying the revenue and other dues to the leasehold property, right now the revenue is paid by the other co-leases, including the respondent number 2.
It is paid in whose name?
It is in their name that there are 4 co-leases.
You are appearing for the co-leases.
Yes, Lordship.
So,
Co-leases. Respondent number 3, 4, 5,
but then
6,
the thing
7.
is that, you see, like the portion of land which is donated does not
was
concern
not-
you, isn't it?
Not at this is a,
You see, like,
this is
we
a,
all is the
this is
along
not,
with the donor, isn't it?
yes.
Now, donor has bequeathed only his part.
As far as their claim is that.
So it doesn't concern you.
No, the property has not been
Partition.
partitioned. It remains a joint property.
Okay.
Now the property cannot be segregated also. That this is the portion and the deed of gift deed was executed in the year 2001 and a deed of rectification was done in the year 2011.
What is that rectification?
Rectification, there were several mistakes were there in para number 2, 4. So those 4, 5, 6 of
So
the
clerical
deed.
in nature,
Yes.
or
Yes,
it
sir.
basically changed the entire
No,
substance.
clerical in nature. Lord.
So anyway, there is a different thing. It will not have any.
Yes.
It will not have much bearing so far as the clerical thing is concerned.
So there is a civil suit pending, Lordship. The parties may,
So, but
the
then see, let the
civil court
cantonment
may
take a
decide
call.
the matter.
Let the cantonment take a call. You see, if they say that they cannot decide it because of the pendency of civil suit, let them pass an order to that effect.
That's, Lordship, it can be disposed of in that way.
Now, which way they are influenced, that we do not know. Whether they pass order in your favor or in his favor, that we do not know, and we cannot direct them to do these things. We can only take note of the order which Mr. Shan has placed before us by additional.
And the application
Seeing
was
that they have adopted two different yardsticks for a similar matter, so that should also be taken into consideration.
the writ petition is also otherwise not maintainable, Lordship, because of delay in HS also.
Okay.
Delay and in the year 2021 only an application has been filed by the son of the deceased person. And during his lifetime also, the in whose name the property has been bequeathed through by way of a gift deed, he had not acquired any right over the property. And the mutation was not carried out because of the objections. So,
Well,
since the
no,
objections
you
were
are saying the
entertained by the
petition-
authorities, there was no ground for the respondent, private respondent, to approach a civil court.
Now, are you
For
saying
any
that writ
declaration.
petition is barred by delay and laches?
Lordship, if the cause of action has arisen in the year 2001 or 2011, then there is a delay of inordinate delay of
Cause
20.
of action comes when there is a refusal to mutate, or when the mutation is applied. Now, when the mutation is applied, 2021.
Even
Now, there may be a delay in applying for mutation, but then there may not be a delay so far as the writ petition is concerned. Any time limit fixed for application, filing application for mutation?
no, Lordship. The objections were duly considered by the contempt authorities.
That we will hear from Mr. Mohanto
Yes,
what he says.
So the annexure 18 of the writ petition, which is the application dated 6 February 2021, the son has approached the authorities, saying that they have stepped into the shoes of their father, and their name is to be mutated.
Page 18.
Page 44, Lordship,
No,
of the writ petition, annexure 18.
annexure 18.
Which page you referring to?
Page 44.
No, that is, this is a representation
Representation by the petitioner's hearing.
for
That yes, the
seeking rejection of the objection
yes,
filed by you. isn't it?
Yes. Rejection and for allowing
No,
their.
that is okay. What do we have to do with this? See, all this thing, let the cantonment board decide. Take a call on that, isn't it?
Lordship,
Whether
since the civil
objection
suit
should
is
be upheld or
suit-
should be rejected.
Civil suit is pending, let the parties contest in the civil suit and the decision of the.
Is there any interim order passed in the civil suit?
No.
Barring the cantonment board.
No
Cantonment
such
board is a
authority.
party in the civil
Oh,
suit.
he is a party in that.
Yes, if it is a party, will it be proper for this court to pass any order at this stage?
Lordship, that is.
They are a pro forma respondent.
They are pro forma
And I'll show
respondent.
Lordships the authorities on this subject, that these are two mutually exclusive issues. Simply because a civil suit is pending does not debar a revenue authority from processing the mutation, because it is not deciding title. It is only for fiscal purposes. I have authorities on this issue. There are similar cases where there was civil suits pending and the prayer was made by the private parties that the entire proceedings should be adjourned or kept in abeyance. The courts have repelled that. This is not an issue. The title is not being decided by the revenue authorities.
No, that is settled law. I
I'll
don't
place
think there
reliance
can
on
be
that.
any dispute.
Yes, I'll place reliance. on
Mere
that.
entry in the
Yes.
record of mutation authority would not make you owner of a property.
And also in the backdrop of a civil suit, they've also decided merely because a civil suit is pending does not mean that a mutation authorities have to keep the matter in abeyance.
Until unless there is a specific order.
Yes, unless there is a specific. In this case, there is no miscase filed by them for any such order.
Yes, Mr. Mohanto.
And Manoj, also, my friend is referred to a letter of 21. I've been writing from 2014. My letters start at page 39.
That is okay. He's said it is about objection. We have not much.
And also, they've not taken the plea of delay. Nowhere has that been taken, Manoj.
Maybe, please, Your Lordship. Your Lordship, what happened? My affidavit in opposition, I have para 7. I've stated the facts. Mainly, Your Lordship can come.
Mr. Upadhyay, you are appearing for response number 567.
Yes.
327.
So, Your Lordship, what happened? They have filed for the mutation, then at the writ petitioner claiming the mutation of the names and HRs in the humble submission and respondent, this Honorable Court is not the proper forum to adjudicate, because this is a disputed question of facts, Your Lordship. This is a disputed question of facts. So it has to.
If you find there is something wrong, you pass an order. Why you are not passing an order?
No, since the objection came forward, because we cannot decide.
See, it is your duty to take into consideration objection and to pass honestly.
Therefore, we have rejected. We said until.
Where is the order of rejection? If you have order, then writ petition becomes infructuous.
No, there's no order of rejection.
Show us the order of rejection.
Because parties has gone to civil court, then should this.
That is all right. Even if you say that parties has gone to civil court and you will not exercise jurisdiction, you pass the order. Where is the order? You cannot remain silent. Are you sure it is rejected?
No, not rejected. Since went to civil court,
said it is rejected.
therefore we have stated that. Further answer states that the writ petitioner has alternative remedy before the civil court, but choose not to go to civil court, and has come directly before this High Court, and before exhaustive remedy available to them, has filed this writ petition. As there are multiple objections from many of the codices and others, as mutation cannot be proceeded, and further they say, give the dated 23/8/2001 and rectification date 1/3/2011, Action 4 and 5, respective of the writ petition, are not in favor of the writ petition, but in favor of late Anwarul Haq. Hence, the writ petitioner have failed to make out a case for interference of this Honorable Court. And
You take a call on that. You take a call.
I
on that.
can take a call.
You can take a decision. You reject, you accept, you keep it in abeyance, but then you have to take a decision.
that we can take it. I'll instruct them.
No, if you do that, then we will finish it in saying that you will take a call on the thing.
Yes, that can be given.
Without going into the details of the merits.
Yes, because we cannot go into a disputed
Then your
question.
purpose will be solved.
Yes,
if
yes,
you record his submission
Absolutely. Lordships only take note
that
of my
your,
rejoinders.
your application prime for mutation will be decided
Lordship.
by the so and so.
Also, my lord, my only humble prayer is Lordships just take note of the arbitrariness and the stand that they've taken in a different case. So that should be a reminder for them that they can't act in an arbitrary fashion. And my lords, just one thing, it may not.
For doing that, then we have to pass a detailed order by
Lordship,
taking
just
into-
by looking into my rejoinder. And just one more thing, my lords, it may or may not appeal to Lordships. The affidavit that has been filed by the cantonment has been signed. The deponent is incompetent to file this affidavit. My lords, please see the first page of the affidavit. It is signed by a sub-engineer. He's not even a party to the proceedings. He has not been authorized. There is no authority letter, nothing.
Oh, he's not been made a
Not
party.
been authorized. He's not a party.
Then your thing is your affidavit is incompetent.
It's a defective affidavit, my lords. And he says that he's been authorized. Where is the authority letter?
So we will not decide anything on the basis of defective affidavit. Yes, Mr. Mohanto.
It says, I, Sujitas, am the
On
sub-engineer.
being duly authorized as a chief judge.
So where is the authority letter?
Oh, I have not given the authority letter.
Then this is it's more difficulty then. Then we cannot pass order.
I understand.
There has to be a proper affidavit.
The authority letters were.
Then you have to file a fresh affidavit then.
I can do that. Or otherwise, your lordship can
Otherwise, you're
dispose
please
of
taken-
direction that we'll take a call on this.
Now then
Because when this
can
matter
you
has
refer
been
to your
pending for
affidavit
quite
of
some
opposition?
time. This was filed in 22, June 22.
22.
You should have raised this objection about the affidavit, you see, before. At the time when it was filed.
In a different court as well, the same thing had happened. Then the union actually withdrew their affidavit.
See, the problem is that, say, like, if we had to pass an order for disposal, then until and unless we get this affidavit corrected,
Lordship.
It will be different.
That's
pass,
one
we
way.
cannot, at least we cannot record whatever has been stated there.
True, Lordship.
If the
Lordship
very,
may ignore this affidavit completely being filed by an incompetent authority.
so
The
we have
fact
to go by
remains,
Mr. Mohanto saying that this
no matter because notices were duly served on the parties, and despite that, they chose to file an affidavit through an incompetent authority. So this goes to them. Even if I don't take an objection, this is something they should have noticed at the very early stage. They cannot file an affidavit by somebody who is not authorized. So this affidavit may be ignored. Ultimately, it does not really cause any impediment with the actual process of this case. Because, my lord, there's the other trouble that if now your lordships direct them to file an authority, this authority will be a backdated authority. In any case, it's from June 22. We don't even know if there was any authority. There is no reference to any authority letter. It's one thing that they refer to an authority letter issued by the CEO.
no, now
and
the
they refer to
appropriate
a date.
officer will pass. The person who is party here,
So we'll
or
have
the
to
person
file
who
a-
is otherwise authorized by law.
Lordship.
Because you see, like, you cannot, if you say that this affidavit is not acceptable,
My lord.
then in such a case, you see, like, that will go without their affidavit. So
Right.
that is one thing. Okay, just we'll just try to pass an order. We'll just sit down. You can sit. Take your seat.
Lordship.
Hard. Mr. S. and Lorna counsel for the petitioner. Come on. Mr. S.P. Mohanto, London Senior Counsel, assisted by your name. Who is assisting you, Mr. Mohanto?
Mr.
Yes. And Mr. S.D. Upadhyay, London Counsel, appearing for the restaurant number 327. You are 1 and 2.
1 and 2, Your Honor. Your Lordship.
Yes.
Lordship, only one small submission. Lordship. That the annexure 1 of the rejoinder, about that Lordship may not make any observation.
You leave it to the court.
That is, yes.
Why?
To the, Because that is on the.
See, that is the basis on which argument has been made.
Suits were mentioned in the. There were 2 title suits were mentioned in that.
That is all right. That is all right. See, it is not about, you see, like, merit of his claim. It is only about adoption of 2 different yardsticks, nothing else. Yes. Okay. The limited grievance raised in this writ petition is about non-disposal of the application for mutation submitted by the petitioner in respect of holding number 13A, Javi Jalupada.
Lordship.
In respect
13A JP.
Okay. In 13
A.
yes, capital A, in JB Jalupada cantonment. You will get it in the petition, the prayer also it is there. What is it? The limited grievance insurance. Insurance by the Shillong Cantonment Board. Stop. There are how many petitioners there?
4 petitioners, my lord.
Okay, so mutation is applied in
The
name of
mutation
all-
was applied for originally in the name of the father. The father expired in 2013. Then they renewed the application.
So now your prayer for mutation in the name of all four persons.
Yes, my lord. Yes.
After demise of your father, you submitted a fresh application.
Yes, my lord. That application is at
It's okay. You
page
have filed-
39, my lord. At page 39,
What is the date of the application?
6th of May 2014.
Okay, it's okay. The,
There are 2 applications, my lord. We also look at page 40. There's a second application which is signed by all the 4 legal heirs for mutation. This is at page 40. Letter dated
so
26.
far as this part of the fact is concerned, it is not disputed.
No, it's not disputed.
So we are not specifically
Lordship,
recording all
Lordship,
those things.
Lordship.
We'll just give the outline of the story.
Well,
and we'll just try to dispose it in a
Lordship.
by passing a brief order. Okay. Then give a paragraph again. The petitioners. The fact of the case. The fact of the case. Fact of the case is that the petitioners are the sons of late Anwar ul Haq, who died on 21/5/2013. Stop. During the lifetime of Said, during the lifetime, or during his lifetime, we just say during his lifetime, late, same name, Arnold so and so, but then these are all your assertions, isn't it? This doesn't go as a fact. What is it? Then just you write it. The fact predated. Just say just the fact predated the petition is that. Just start the paragraph like this. The fact predated in the writ petition is that the petitioners are the sons of late so and so, late Anwarul Haq, who died on 21/5/2023. Stop. During his lifetime, late so and so was the owner of 1/4 share.
Well, it's in the original gift deed, it mentioned 1/4. In the rectification, they corrected it. It was not 1/4. It was the entire share. Entire leasehold right was transferred.
But then
That is why
your petition says it is 1/4.
yes, my lord, because it is on the basis of the original deed of gift. So if your lordship will just see the deed of gift for a moment, that is why a deed of rectification was executed.
Okay, then we will not say what we said. Was owner of a leasehold property. Covered by holding number 13A, 13 capital A, then J stop, capital J stop, capital B stop, Jhalupada cantonment, comma, Shillong, which was gifted to him by one of the original policy of the he was the original, the person, right?
Yes, my lord. He's also arrayed here as the respondent number 3.
Original policy of the property. Acha, he is the respondent number 4.
3, my lord.
Right.
S.K. Mohammed Sadiq.
But the petition says who?
I apologize, man. This must be a typographical error. Very sorry, my lord.
Come to your synopsis, you say it is 4.
I apologize, my lord. This should be number 3. Very sorry, my lord.
This is by Muhammad Sadiq. It was gifted to you by Muhammad Sadiq.
No, respondent number 3, S.K. Mohammed Sadiq, sorry, correct.
Yes.
S.K. Mohammed Sadiq.
What? Just that last part you just said, which was gifted by the respondent number 3. By the respondent number 3. One of the lazy, comma. Who was the lazy of the committee? One of the original lazy of the committee. Actually, you write gives him S.K. Muhammad Sadiq, who is included as the respondent number 3 in this writ petition. Who is the respondent number 3 in this writ petition? Stop. The property was. It is stated that the property was gifted by a valid gift it registered on 23/6/2001. Is correct? 23/6/2001.
Lordship. Lord, I think here also there is a mistake. It should be 23/8. I apologize. This is a typographical error.
You should be
In my
careful.
brief
Then
synopsis.
if you see if it doesn't help the code, then
What is
the purpose of them doing this?
I sincerely apologize, Lord. These were some typographical errors in the petition. It should be 23/8/2001.
23/8.
2001.
What is it? It is stated that the gift valid deed of gift, D capital G, deed of gift, dated 23/8/2021. Registered after obtaining prior approval from the Cantonment Board, Shillong. The said gifted subsequently was corrected by a deed of rectification dated 1/3/2011.
Yes, my lord.
Yes. You can sit down, Mr. Sen. So after the registration, after now you have your father made a mutation application. Where is that?
Lordship. The mutation application is not with me. We've made a statement, but against the mutation application, I was directed to submit an amount of money that is at page 28, and the reference to my mutation application is
Page
made.
28.
There.
No, where is in the petition? In the petition, do you?
Lordship, I have made a statement. Just a moment. At page 6, para 7, my lord. And I've stated that it is not in my custody as well.
Okay, just stop. After the execution of the gift deed. Come on. Take your seat, Mr. Sen.
Lordship.
Late. Anwarul Haq applied for mutation of the property in his name. In the year 2012. In his name in the year 2012. Or shall we specifically quote the letter? Dated is 22/11/2012.
Lordship.
Is it correct?
Yes, ma'am. Because if your lordships look at the reference letter, subsequent correspondences with them, they've also made a reference to that date.
Just tell us, just last part. Just last. No, by letter dated. Do not say by letter dated 22/11/2012. Stop. Then when did he pass away?
My lord, he passed away on 21/5/2013.
Stop. However, before the property could be muted in his name, comma, late Anwar ul Haq passed away on
21/5/2013.
2005. Stop. Thereafter, the petition being the rightful legal heir. Therefore, the petitioners, comma, being the rightful legal heir, comma, applied for mutation of the property in their name by when where is your application?
We'll find it at page 40.
40.
40. It's letter dated 26/2/2015, my lord. In the top right corner, but this date may not be very clear. 26th of February 2015.
You have mentioned it in your
Yes,
petition.
my lord, in my petition.
Okay. Just say why. What is it? Why letter dated
26th February 2015. These are all handwritten, my lord. So while photocopying, that entire carbon disappeared.
No, if something is not legible, your duty is basically to reflect it by annexing a typed copy.
Lord.
Now, your grievance is that this application has not been disposed of.
Lord, it's not been disposed of.
Since the respondent number 1, 2. Okay, what we said, the so and so has applied. To the so and so. Address to the. Let us say so and so address to the. Respondent number 2, the Chief Executive Officer. Okay. Respondent number 2. Stop. Give a stop. Since the application for mutation submitted by the petitioners has not been considered, comma, the petitioners approved this scope for passing appropriate direction to consider direction for consideration of the mutation application by the respondent number 1 and 2. The same next paragraph, Mr. Sen, Lordy Counsel, appearing, Mr. Sen, Lordy Counsel for the petitioner submits that the respondent number 1 and 2 are duty bound to consider and dispose of the mutation application, to dispose of the application for mutation application was submitted by the petitioners within a reasonable period of time. He submits that in spite of several persuasions by the petitioners, comma, the one number 1 and 2 have not disposed of the application submitted by them. He submits that though the objection has been raised against the prayer, against the claim made by the petitioner by the respondent number 327, comma, the same cannot be a ground for non-disposal of the application of the petitioners. Stop. He further contends that the time that he further contends that at the time of filing of the mutation application, comma, there was no such objection from any quarter, including the respondent number 327. However, the respondent number 327 raised their objection against the prayer of mutation by the petitioners only recently. by filing a civil suit against them. He submits that there is no interim order passed by the civil court debarring the cantonment board from considering the application filed by the petitioner, and hence necessary direction may be issued to the respondent number 1 and 2 to dispose of the mutation application filed by the petitioners within a specific period of time. Stop. Mr. SP Mahto, London Senior Counsel, appearing for the restaurant number 1 and 2. Submits that the pendency of the civil suit filed by the restaurant number pendency of the civil debt involving the property in question is the ground for is the reason for non-consideration of the application of the petitioners by the Contempt board. Stop. He, however, submits that if any direction is passed in this regard, the Contempt board would definitely take up the application for mutation submitted by the petitioners for consideration and pass necessary order as deemed appropriate. Stop. Next paragraph. Mr. S.D. Mahatta, London Council appearing for the restaurant number 327, has objected to the prayer made on behalf of the petitioners. Stop. He submits that the gift deed in question, which is made the basis of for application for mutation application, was not executed by the donor with sound mind and health. Stop. he submits that a civil suit bearing title suit number, what is that number?
2H of 22.
Has already been filed by the register number 327 against the petitioners seeking cancellation of the gift deed. Stop. He therefore submits that since the claim of the petitioner is already disputed, so he further submits, before that decision, he further submits that the respondent number 327 have already lodged their objection against the prayer of mutation made by the petitioners before the cantonment board. You filed your objection there also, isn't it?
Based on the
Yes.
objection of the
Stop. Then you say he therefore submits that since the respondents have, since the respondent number 327 have already disputed the claim of the petitioners, it will not be appropriate for the cantonment board to take up and consider the prayer of the petitioners for mutation of the property. Stop. Next paragraph. The submissions advanced by the rival parties are considered carefully. It appears carefully, the submissions made by the learned councils have been considered carefully. Stop. It appears from the materials on record that after the execution of the gifted and subsequent deed of rectification, an application seeking mutation of property covered by, write the details of this property. Just this one is application for property covered by so and so was made initially by the father of the petitioners and subsequently by petitioners. Stop. In spite of lapse of almost 10 years from the date of the submission of the mutation application by the petitioners, no order in this regard has been passed by the respondent number 1 and 2. Stop. It is an admitted position that there is no interim order passed by the civil court dividing the cantonment board from considering the application filed by the petitioners. Stop. Though a plea has been raised by the learned senior counsel appearing for the Cantonment Board that the pendency of the civil suit is a bar for the is a bar for consideration of the application, comma. It is pointed out by the learned counsel appearing for the petitioners that in similar case the Cantonment Board had applied a different yardstick to pass to allow mediation, to do not have to pass, to allow mediation in respect of some other property by order dated 11/6/2020. 20. What is it in respect of? Just some other property covered by holding number 3, then capital J, capital B, then SY number. You will get it in the affidavit file, not the writ petition file, affidavit file at page 67. Okay, in the affidavit of the file, last page. Okay, serial number on the top, you will find it, the number. Just please tell the last line. What we say? It is pointed out by Mr. Shen. It is pointed out by the learned counsel of the petitioner. They are depending yardstick. Respect of so and so in spite of pendency of a civil suit. Stop. Give a paragraph. As there appears that there is no bar for the Cantonment Board to consider the application for mutation filed by the petitioners. What is it? As there appears. No legal bar for the so and so by the Contempt Board to consider the applicant filed by the petitioners, comma. This court deems it appropriate to direct the Cantonment Board to take a call on the application for mutation filed by the petitioners. How much within a period of?
Within 2 months, I think.
Period of 2 months. But it is made clear while considering the application filed by the petitioner, comma, the objection filed by the respondents number 3 to 7 shall also be taken into consideration.
If it can be incorporated, there is no injunction from the civil court, I think.
That's we have said this is there is no interim order. We have already said,
Okay.
barring this thing.
Yes.
That is what. There may be some correction and all way. So like sometimes the dictation in the courtroom is not always correct. So there may be a bit, but then order will remain more or less.
You know, I'm sorry for the authority letter, I think, didn't enclose. Anyway, I'm sorry.
No, that is all right. Actually, but then actually it should not have been taken on the record.
Yes, yes.
Because you see, like if you are a party, then okay, there is no problem. If any subordinate was a party, you can file. But then if he's not, then I think there's a law. See, like there's a thing like the
Yes.
person holding
Lordship.
rank, like at least the minimum level has to be there.
True,
See,
true.
like you cannot be that you can tell your subordinate officer to do it.
Lordship.
There's no.
Anyway, deeply obliged. Lordship.